はい、それでは次の講演です。次はプライバシーシールド後の生活、データ転送法は世界のビジネスを止めるかについてジョナサン・アームストロングさんにご講演いただきます。ジョナサンは英国のリスク、コンプライアンス、フィンテックで6番目に影響のある人物として評されていらっしゃいます。2016年にはデータセキュリティトップ100インフルエンサーとしても評されています。またブランド調査でオナリティカによって世界で14番目に影響力のあるデータセキュリティの人物としてランキングされています。2002年から今日までスーパー弁護士としてリーガルエクスパーツとしてリストされていらっしゃいます。ジョナサンさんからは今回のテーマについて動画をいただいております。動画が終わりましたら皆様からのご質問を直接ご本人にお聞きしてまいります。Our next session is Life After Privacy Sealed. Will data transfer law stop the world doing business? Please welcome our speaker, Jonathan Armstrong.
Konnichiwa, I'm Jonathan Armstrong from Caudry, the specialist compliance law firm in the UK. And I'm very pleased to be with you, at least virtually. Obviously, I'm disappointed not to return to Japan. I had an excellent visit there last year, and I know I met with some of you then, but hopefully when the current pandemic subsides, we can meet together again in person. And let me also thank my friend, Mr. Takahashi, for inviting me to speak at this event. He's obviously a foremost authority in some of the things that I'm going to talk about, and I'm very grateful and honored to have been invited to speak to you today from my home in the UK. So what I'm going to talk about today is I'm going to look at life after Privacy Shield. I'm going to talk a little bit about the background to the latest installment, not the last, but the latest installment in the Schrems litigation. I'm going to look at what it might mean for different jurisdictions around the world, and I'm going to look specifically at what it might mean for Japan. Now, it's important to remember that all of this litigation is very important for legal professionals and for security professionals as well. And indeed, anybody in Japan, because I think it gives a restriction on some of the ways in which you can do business with Europe, but also it gives opportunities to companies that do things correctly and particularly to information security professionals. The Schrems cases, if you like, increase the level of security in organizations and the importance of security professionals as a result. So it is, in my view, an opportunity as well as a threat. So let's look first at the background to all of these things. Now, many of you will remember the Schrems litigation and how it started. And I've been fortunate enough to follow this litigation for many years, and indeed to speak to Max Schrems on a number of occasions and to interview him at conferences. Now, in some respects, this all starts back in 2011, some 9 years ago now, when Schrems attended a lecture whilst on a gap visit to Santa Clara University. He had a discussion then with a representative from Facebook who was a guest lecturer in class, and he made a subject access request to Facebook as a result. Now, subject access requests, for those of you who don't know, are a process under the old EU data protection law and under the General Data Protection Regulation, GDPR, where an individual can say to an organization, in this case Facebook, give me all of the data that you have on me. And so Schrems served that request on Facebook, and he was disappointed with the reply. He got more than 200 pages, but he thought that was not enough and that they had more data on him. and he therefore made a complaint to the Data Protection Commissioner in Ireland about Facebook and the way in which it had handled his data. And he made the complaint in Ireland because Facebook's international operations were based in Ireland. Now, in July 2014, the Irish High Court referred the Schrems 1 case to the ECJ, the European Court. And by that time, of course, Edward Snowden had made his allegations about the activities of the US security services. And that made the situation more difficult for Facebook because it was harder for them to guarantee that Schrems's data was safe in the US if the NSA could look at that data. And so, as a result, in October 2015, taking into account the Snowden allegations, Safe Harbor, the mechanism that many corporations had used to transfer data from the EU to the US, was struck down. Now, the litigation did not stop there. In November 2015, Schrems had brought a second action, which was effectively a civil action seeking damages. He said, if Facebook have handled my data incorrectly and handled the data of many thousands of other people incorrectly across Europe, then we should be paid money as a result. And that case, the Schrems 2 case, is still progressing through the courts as individuals seek compensation against Facebook. Now, in December 2015, Schrems brought another complaint to the DPC, this time against something different called standard contractual clauses. Facebook had said, okay, we don't use Safe Harbor anymore because that's gone, but we'll use some special types of clauses instead to transfer data. And Schrems made that complaint. In July 2016, Privacy Shield was adopted, a new scheme for the transfer of data to replace Safe Harbor. And eventually, the case that was going to the European Court about standard contractual clauses had Privacy Shield joined onto it as well. And as we know, in July 2020, Privacy Shield was struck down by the ECJ. Now here there's a point of confusion. Some people call that case Schrems 2. In fact, it's Schrems 3 because, as I've said, there was this civil action as well. But Privacy Shield was struck down by the European courts, and Switzerland and Israel have followed as well. So what does this mean? Well, first of all, I think that the situation, the primary responsibility for fixing all of this is with the US administration. The European Court criticized the fact that the US administration does not protect the data of European citizens, and obviously it doesn't protect the data of Japanese citizens as well. So will Trump build bridges? Well, in my view, I think this is unlikely. It's obviously an election year, and in 4 or 5 days' time, we might know the result of the election. There's clearly an increased focus on security in the US, and lots of xenophobia, this fear of outsiders in the US, and particular sinophobia, this fear of the Chinese, and this fear that Chinese organizations and the Chinese government wish to take the US over. And it's important to remember that Obama, in European terms, was regarded as being much more compromising, more understanding of privacy rights, and yet his administration could not provide a fix. So it's difficult to see how any Trump administration could provide a fix. If the election changes the complexion In the US, of course, the situation could be different. So, how does this lead to any sort of resolution? Well, first of all, businesses could try and use standard contractual clauses. These particular special types of legal agreement to transfer data. And incidentally, this bit of the judgment also applies to Japan. There is no safe harbor scheme with Japan. There is what's called an adequacy finding, which we'll discuss a little bit about later. But you still need an agreement to legitimize the transfer of data to Japan. And effectively, in very simple terms, the court said that you need to do two types of due diligence for standard contractual clauses. You need to make sure that you know who you are sending data to, and you need to make sure that you know the legislation that applies in that country. So if I'm sat in the UK, for example, and I'm transferring data to Toyota, I will need to make sure that Toyota is reliable and also that Japanese law has protections for data. So standard contractual clauses will be the way in which most organizations will make the transfer of data lawful, at least in the short term. There are other potential avenues to explore, such as binding corporate rules, but standard contractual clauses will be the main one. Many businesses are trying to avoid the issue. I have heard this week from two of our clients who say that the US administration has told them to carry on as normal because a new privacy shield will appear. I think that is very unlikely. If it does happen, the courts will also strike it down. Many corporations are trying measures of self-help, and that could be things like having an ombudsman scheme. It could be things like having external security assessments on their data. And it could be things like undertaking to tell people when government is trying to look at data insofar as that's legally possible. And we're also likely to see reassuring words from the European Commission as well to say that a new agreement is on its way. As I said, I don't think a new agreement will be lasting. But despite those sort of four things that look at resolution, there are many things that make this more difficult. Firstly, there is litigation. Already, a German group has taken action against Amazon and issued proceedings in Munich in Germany to effectively say that because Amazon says it uses Privacy Shield, it breaches the General Data Protection Regulation. And that is a significant case if it can run. Breaches of GDPR are punishable by a regulatory fine of 4% of global revenue, in Amazon's case, a very large number, and the civil action might entitle individuals to damages, and that's what the German group is seeking. Regulators will act. I would think that German regulators, again, are more likely to act than many. And there is, of course, a Schrems 4 litigation where Schrems is going back to court to try and force the Irish authorities to take action. And they do say that they are accelerating their investigation into Facebook. So there are some big threats on the horizon. And again, information security professionals will have a role to play here by trying to persuade people they do business with that their processes are better than other people's. Now, I'll just mention in passing that, as I said at the start, the Schrems judgment is not limited to transfers between Europe and the US. It will also have an effect, for example, on transfers to Russia and China. They will possibly be subject to greater scrutiny because of laws that Russia and China have adopted around the localization of data and access to data by state authorities. Why Russia and China haven't been prominent on the radar is because there is less commercial impetus. Many European businesses outsource HR to US corporations. They outsource travel management to US corporations. They outsource HR and sales databases to US corporations. Very many fewer use Russian suppliers and Chinese suppliers. But I think we will see these tensions rise, particularly as Chinese connected offerings gain in prominence. And we've seen a flavor of that in the moves from the Trump administration against TikTok, where they're almost mirroring the concerns in the European court, whilst disagreeing with the European court's reasoning at the same time. And what does this mean for the UK after Brexit? Well, I think this is going to be a somewhat complicated situation because there is a political agreement to be reached, and without being political, our current government, led by Boris Johnson, is not negotiating as well as it should. And at the same time, UK legislation and the perceived activities of the UK security services has also been criticised in mainland Europe. What does this mean for Japan? Well, I think Japan has done well in terms of its negotiating strategy with the EU. And obviously, Japan has favoured nation status as far as the EU is concerned and as far as the UK is concerned. And the UK has said that it intends to replicate the favoured nation status of Japan with the UK when the UK finally departs the EU. I think there is likely to be greater focus on adequacy. And I think in some respects, this is where the Japanese authorities have done well. So, for example, only recently, you announced higher fines for privacy infringements. I think they come in on the 12th of December, and fines rise to potentially 100 million yen. That will be seen as a good investment in privacy by EU and UK authorities. We may see annual reviews of adequacy decisions going forward, particularly if there is some pressing imperative. So, for example, if there is a big data breach in Japan which affects EU citizens, there is likely to be a greater political emphasis for more supervision of Japan. There is the possibility of greater scrutiny of the activities of the Japanese security services. So there has been some criticism of the inquiry sheet system in Japan and some low-level commentary on some of the Snowden allegations about Japan, such as programs such as X-Keyscore and Mallard. I think, again, they're not really in the public knowledge as much as the activities or the alleged activities of the NSA are in mainland US. But this is something that Japanese businesses and Japanese security professionals will need to keep monitoring. There's likely to be greater scrutiny of laws protecting the data of non-Japanese nationals from state surveillance. So, for example, the new PPC English language helpline, I think, is a very useful development, again, to try and reassure European citizens and UK citizens that Japan cares about privacy. There is more prospect of pressure group activities, and there is more potential for class actions like the class action against Amazon. And as I've said, a real benefit of this is the greater role for InfoSec professionals, for cybersecurity professionals, for legal professionals in decision making. So I guess one of the big questions, though, is, can national security and data protection ever survive together? And you might see that I've used some quite quirky photographs to illustrate my talk from my visit to Tokyo last year. And this, it seems to me, is a little bit like Peter Rabbit. It is a fairy tale, a land of make-believe. I think there is always a tension between national security and data protection. And equally, we see in areas like the right to be forgotten under GDPR, bad people use good laws to do bad things. So we are always going to have this tension between protecting state interests and protecting data protection rights. And in my view, this means that we're going to continue to have litigation like the Schrems litigation, continue to have disputes over the transfer of data. So in my view, it is unlikely that data protection and national security can ever have a perfect marriage. So how can organizations in Japan minimize risk? Well, I was touched when I went to Kyoto by this sign telling people that they must stop Pokemon Go when walking round the monuments in Kyoto. And I think that's a good example of how organizations in Japan can minimize their risk. They need to give clear instructions both to their own individuals and also to the people they are dealing with. They need to be very transparent with people and explain how they will protect data and the measures that are in place in Japan to ensure the protection of personal data. So first of all, this will be about setting out very clear rules. This is how we handle your data. This is how we keep it secure. There needs to be a very strong emphasis on security. You will need to look at standard contractual clauses. They're sometimes called model clauses. They are not perfect, but they are probably the best thing possible. You need to be prepared to explain the limits on Japanese law. In some cases, this might mean that you need a formal opinion from Mr. Takahashi or eminent lawyers in Japan to explain the protections that exist in local law. You will need to look at other measures, for example, potentially an ombudsman scheme to deal with complaints from individuals. And you'll need to have a proper process in place to make sure that you can deal with requests for data properly. And remember that that's how the entire Schrems litigation started. One man made one request for his data, and he was not satisfied with the reply. So one individual can change your world. And as a result, you have to be aware of how you deal with employees, how you deal with customers, how you interact with people if you're a large company, because one man can change your world. Now, I'm I know that I've spoken quite quickly and that my English is sometimes quite hard to understand. And so I've left some FAQs on the screen here where you can look at these specific links for some of the topics that I've discussed. The first one is a general introduction to GDPR. The second one explains some of the words that we use in data protection and in information security in the UK. The third one has some notes on the Schrems 3 case and a short film. There are some details of the Swiss Privacy Shield collapse there. A short film about the first 2 years of GDPR and some of the other cases that we have seen on data breach, for example, and data security concerns. There's an article on the same topic. We've done a lot of work around corporate investigations and the issues between GDPR and data and corporate investigations. That's on the next link. We've done some work around Facebook and data protection impact assessments, which are a useful way of minimizing risk, on the next link. And then we have a film on brands in a crisis that you might find useful, and some details of the Amazon litigation over Privacy Shield in addition. Now, it's been my pleasure to speak to you. I hope that that's given you a flavor of some of the tensions between data protection, data security, and national security. Of course, I'm available to answer your questions now, hopefully in the chat if that is working. And if that isn't working, do feel free to reach out to me via email, and you can follow me on Twitter. And all that remains to say is that I've been very honored to speak with you. Thank you so much for the invitation. And I hope that you have a very interesting rest of conference. So thank you very much for watching, and I hope to see you in person before long. Thank you.